aware, this is complex. If you look, and I believe the Review Journal said so,
Go ahead and state your appearance and begin with plaintiffs.
Morning, Your Honor. Eric Pepperman for plaintiffs, and I believe Eddie Parker will be joining us shortly.
good morning, Your Honor. Colt Dodrill and Karen Basher for defendant Nevada Beverage.
Morning, Your Honor.
Good
Morning, Your Honor. Jim Cavanaugh, Gordon Reese, for defendant ETT1 LLC, DBA Terrible Herbst.
Good morning.
Morning, Your Honor. Dan Polsenberg and Corey Corkridge, also for ETT1, doing business as Terrible Herbst in the Milo Herbst estate case.
Good morning.
And Tyler Watson and Jake Studi on behalf of Real Water Defendant.
Good morning. All right. Okay. So we've got well, probably we should talk first, I suppose, about the defense motion to continue and deconsolidate. Read that. Plaintiff's opposition, defendant's reply. Then we've also got jury questionnaire motion and status check. Probably inclined to deny the motion to continue and deconsolidate. I'm certainly going to grant some form of questionnaire, if not exactly this. And you are super old, so to speak, the underlying original cases. So. But welcome arguments on the first on the motion to continue and deconsolidate.
Thank you, Your Honor. Good morning. Colt Dodrill for defendant Nevada Beverage. To address the court's concern about the age of the case, the Milo Herbst estate portion of this case is not old. Mr. Herbst has not been dead for a year yet. This case was just filed in February. I believe we answered in March. They moved to consolidate in April. I believe that was granted over our objection in June. In terms of the, if I could start with the continuance portion of that, there's a lot going on in this case, and there's a lot of recent developments in this case. And today is November 12th. Today is the trial readiness conference, and I can't come to the court today and say I think we're going to be ready. I still have not deposed plaintiff's medical causation expert. These coordinated cases, at least, have been going on for 4.5 years, and in the last 5 trials, their special causation expert, their medical causation expert, had been Dr. Hudson, whom I've deposed 4 of the 5 times he's been deposed. In this new case, here, they have a new expert, Dr. Khan. He's an unknown entity, and we need to depose him. And his deposition, he was not being made available until November 19th, which is the last day of discovery. Before I move to Dr. Kosnet, Dr. Khan is making a unique claim that we've not seen in any of the prior real water cases, including the one Your Honor presided over, which was the Wren trial. And that is that it's not just hydrazine, which obviously we don't agree with the hydrazine, and you'll see motions on that. It's hydrazine plus. And in this case, they're claiming it's hydrazine plus alcohol. That's a new theory. That's a novel theory that we'd not seen before. And we're entitled to take Dr. Khan's deposition. And like I said, that is not until November 19, the last day of discovery. Dr. Kosnet is their medical toxicologist, and he has changed his opinion, and he's now saying it's hydrazine plus, and in this case, alcohol. And so he has a new report. We get to depose him, and he was only being made available on the 18th or the 19th, and he obviously can't be in 2 places at once. So we asked to depose him on the 18th. Milo Herbst, and as you've seen, and you'll see this in some of the moving papers to be decided, when we come back in 3 weeks on some early summary judgments is addiction. Milo Herbst owned a wine bar. He referred to himself as a wino. The medical records show he had 60+ years of consuming wine on a daily basis. And so that brings yet a new witness to the expert field, which in this case is an addiction expert. And we have Dr. Moss, and he's been deposed. Plaintiffs have rebutted that with Dr. Sands, who to this day, I still don't have a deposition date for, which indicates he's going to be deposed after the close of discovery and perhaps after the November 25 dispositive motion in limine date, which is going to back everything up. There's a number of medical providers that had been deposed. Early in this case, we didn't think we needed them. The medical records seem to suggest what they suggest, and even plaintiff's counsel seems to agree with us that we can use those medical records, and they are admissible. And those are all medical records that say Milo drank 1 to 3 or 1 to 2 or 2 to 3 glasses of wine daily, every day. Been a wino since he was 12. But then plaintiffs went on a campaign to depose and identify a number of fact witnesses, friends, and acquaintances in an attempt to challenge and undermine the medical records, which out of abundance of caution and due to our obligations to our clients and our right to have a full and fair trial, we want to depose those folks. And we noticed that several of those treating physicians, Real Water, has also noticed a number of those. And that really backs up our deposition and discovery schedule. On top of this, in October, on 3 consecutive days, plaintiffs filed 3 consecutive motions for summary judgment. While we are trying to prepare for meaningful expert discovery and meaningful depositions, we've had to respond to motions for summary judgment on statute of limitations, which we included our counter motion, which we were planning on renewing our motion on November 25, the dispositive motion deadline. We were forced to spend time to oppose that motion and include our own. So the court had all the information in front of it, so that can be decided on December 3rd. The following day, they filed a motion for summary judgment on what I still call collateral estoppel, what is now issue preclusion, based on the verdicts in the prior Real Water cases. Those motions were directed against against Real Water, and out of an abundance of caution, and based on some arguments counsel made in the Brown case that was before another judge, Judge Williams. There was some discussion that maybe they would attempt to use judgments against Real Water to have a preclusive effect against other defendants that were not parties or subject to those judgments in those other trials. So we've had to spend 2 weeks opposing those, and we included our counter motion. Again, a factual and legal substantive motion that we did not plan on filing until November 25, the dispositive motion deadline. The next day, the plaintiffs filed their 3rd motion for summary judgment, this time arguing judicial estoppel based on admissions and stipulations that Real Water made in prior cases. And you'll see our briefing on that. We had abundance of caution. We have to oppose that. Real Water opposed that. And we joined Real Water's opposition. And we included that in a joint opposition, and again, had to include what we felt was our appropriate counter motion, all during time that we would have otherwise spent preparing for depositions, preparing for experts, and working on preparing for trial.
So I was trying to avoid this question, but I think I have to ask based on your arguments, which is heavily emphasizing, hey, we don't have time, we can't do depots and oppose motions simultaneously. So, you know, one of your primary arguments certainly is we don't have resources, is what I would boil it down to, I suppose. So doesn't that beg the question? I mean, just looking at your caption here, we've got law firm Gordon and Reese, we've got law firm Shepard Mullen, we've got law firm Wilson Elser. Hundreds, if not thousands of attorneys.
Your Honor, there's numbers of attorneys. Shepard Mullen represents ETT1 doing business Terrible Herbst, not Nevada Beverage. Gordon Reese represents ETT1 Terrible Herbst, not Nevada Beverage. Yes, Wilson Elser has a number of attorneys, and we have a robust team. That's not the question. It's a balance.
Well, how is
Your
it not
Honor,
the question when one of your primary arguments is we don't have the resources? So
we have physical resources and we have people. What we're focusing on, our concern is quality. You look at, and it's time. We have people, we don't have time. This is a motion based on time. They're trying to ramrod the Hearst case in with other cases that have been pending, and this dovetails into this deconsolidation portion. We just learned 2 days ago when plaintiffs' counsel deposed our toxicologist, Dr. Stelpflug, STLLPFLUG, that they expect us, there's 10 other folks in this case, 10 other plaintiffs that are not suing my client. They're expecting our experts to have intimate knowledge over the other plaintiffs' medical records, the other plaintiffs' unique comorbidities, the other plaintiffs' real water consumption. In addition, what came up at that deposition were questions involving plaintiffs in prior cases. Miles Hunworthen, who underwent a liver transplant and was tried years ago in Judge Kishner's courtroom. TaQuante Henry, who underwent a liver transplant and was tried in a prior case. And I've settled out on those cases and I've put those to bed and in the back burner. But now it's not just, oh, I got to spend time on a motion when I want to prepare for Dr. So-and-so's deposition. And I have to defend our expert's deposition, to do 20 some odd expert depositions and doctor depositions in a 2.5 week period is insane when they're overlapping. And these experts now have to get engaged in dozens, if not hundreds, of other medical records of folks that either aren't or are no longer suing my client because of interplay using one expert against another and a whole host of stuff. And I don't want to get into the weeds on all that. You'll see that on motions in limine, and you'll see that on some summary judgment motions that are coming up on the court's calendar on December 3rd. And it goes beyond, oh, we need to prepare for depositions going on the 19th. There's a number of depositions that are going on beyond the close of discovery. There's been a number of depositions requested recently that are most likely based on the existing deposition schedule going to be going forward after the 19th. And I would encourage the court to take a look at what's going to happen after the 19th. We got to turn around in 4 business days and file about 50 pretrial motions. That includes motions for summary judgment. Most of the motions would be motions in limine, many of them new and unique to this case, the unique circumstances regarding Milo Herbst, some of which I alluded to earlier, some I'll go into when we talk about the deconsolidation. When are those oppositions due? We can't just file a bunch of motions on the 25th and leave and catch up. No, we're going to oppose plaintiffs' motions. And based on the history we've seen, and I've been in the real water cases since they began 4.5 years ago, I have a good idea of at least the volume of pretrial motions. And Your Honor heard many in the Wren case. And this case raises a number of, again, unique issues based on what is a substantial history of alcohol consumption going on for 60 years and all the attendant issues that raises. And so my back of the napkin math and some of these dates we will get today as part of the trial readiness conference is we're looking at December 9, oppositions due. Replies will be due either by stipulation, court order, or as EDCR 2.2 allows, which is essentially 1 week before the hearing date, which we don't have yet, and we'll have to coordinate with the court's schedule because you can imagine how big that is. And in the meantime, if you look at that, that butts us up pretty much against the trial date. And that is the time when we're reviewing all these jury questionnaires in whatever form they are that go out. They will come back. Those have to be reviewed. And we need to prepare that as well as openings and witnesses and lists. And Your Honor will tell us at some point when you would like the pretrial memo, and those are all things we need to do. The exhibits on this case, and Your Honor knows that from seeing the Wren case, will be exorbitant, especially in a consolidated case with now 11 patients, one of whom has passed away. That's substantial, and that butts us right up. And we saw that happen. We saw that play out in Gallagher, and counsel will say, we've done it before. We can do it again. We can, buckle up and have our Wheaties and take our vitamins and get everything done. Our concern is we saw the results of those cases. When they rammed Gallagher through, what did it result in? A nuclear verdict, punitive damages. They ramrodded Hunwards through expedited trial setting. One of the plaintiffs in that case qualified, ramrodded that through. It was rushed. Everything was rushed. We're not looking at great preparation. We're not looking at great quality. And what happened? The nuclear verdict, punitive damages. And then, and Your Honor, this does dovetail, so there's some overlap, save some time for this argument, into the deconsolidation. What happened? Plaintiffs' counsel started consolidating cases, and what happened? The punitive damages skyrocketed from hundreds of millions to 3, 5, and then again 3 billion with a B dollars. That's prejudice, and that's the result of forcing a number of plaintiffs or patients, because we have a decedent here, together in this mix and match and the prejudice and the bolstering and everything that you saw in our argument, as well as the time frame. You should be preparing for trial. The jurors benefit, the court benefits, the public and justice in general benefits when witnesses are properly prepared, when counsel are properly prepared, and not jumping and playing whack-a-mole from one spot to another in rapid succession, like we're on the last round of the game show. This is justice. Nevada Rule Civil Procedure 1 focuses on fairness and justice, and pushing this through in short succession, where every date butts up against the other date, every task butts up on the other task, and the attorneys don't have time, regardless of the quantity, to stop and reflect. Okay, we deposed Dr. So-and-so. What does that mean? How do we do that? What's going on? How can that be presented to be meaningful to the jury? How can that be presented? What needs to be done? And that's on both sides. That's on both sides of the aisle. And I'll say this, plaintiffs' counsel have tried this case. They've tried it 5 times. They know the case inside and out. And I'm not saying they're not going to prepare, and I'm not saying they don't have to look over things. They've tried it. They know all these issues like the back of their hand, and maybe Your Honor does too from presiding over the Wren
Well, I
trial.
mean, my trial was what, a year?
24 year.
June 24. Okay, I was gonna say a year ago, apparently more than a year ago. So I mean, I remember it, but yeah, I apologize. Go
No,
ahead.
that's fine, Your Honor, and I appreciate the insight. We've not been at trial. We've either not been parties, or we've been voluntarily dismissed out, and in some cases we've settled out. We've not been there. We've not. Maybe sometimes we've observed, we've read, we've looked, we've seen it. We don't have that intimate knowledge. This is stuff that needs to be prepared. This is complex. If you look, and I believe the Review Journal said so, and I believe it, that $5 billion verdict was the biggest verdict in the history of the state of Nevada. And I know from talking with counsel and from having 2.47s in the other case that they plan on going for more. You'll see that when the jury questionnaire comes up. They're talking about billions and billions and billions. So if this is $1 billion case, and if this becomes the biggest case, and they have more defendants in this room right now than that went to trial in the Wren case, which I believe proceeded only against Real World. We need time. The scales of justice, and I'm not being learned hand here, but the scales of justice say, based on the gravity of the case, and if I can paraphrase our discovery rules, proportionate to the needs, you see that comes up. What's proportionate to the needs of this case, where they're going to come up and tell the jury, you know, we're going to try to kick it out on motions, but they're going to tell the jury, hey, you got to award X billions of dollars. And I can't put words in plaintiff's counsel's mouth. I don't know if they're going to say 5, 10, 20, 100. It's going to be insane. It's NFL money. And based on that volume, that exposure, that power, we're just asking for a few months. May. That's fair. That's just. And it feeds into the deconsolidation. And if Your Honor will allow, I'd like to go into that now, or we can do them separately, whatever works for you.
Well, I mean, now's your time. I'll have to tell you though, I'm in trial. And you're not the only case this morning. So at some point I'm gonna have to tell you, hey, your time's up. Let's hear from the other side. Because I have read it all. So let's give you 5 minutes more to talk about the rest.
Perfect, Your Honor. To wrap up the timing, there's still a pending motion to compel, pending with the special master on unredacted credit card statements based on newly produced evidence that plaintiffs are claiming Mr. Herbst, who has no record of purchasing real water, was a cash guy. And I'm trying to figure out if he was a cash guy and paid cash, why do we have 1,100 pages of credit card statements that they produced, heavily redacted? And we're waiting on a decision from the special master on that. Moving on the deconsolidation, you've seen the briefs, you understand our prejudice concerns. We're prejudiced, there's bolstering. And I think I brought this up on the original the original consolidation motion. Mr. Herbst sticks out like a sore thumb. It's not night and day. This is the difference between night and an orange. And he's vastly different. And Your Honor had previously severed Leela Cavanaugh from the Wren case. We referenced that in the briefs. And it's because she had, instead of acute non-viral hepatitis, she had autoimmune hepatitis. The contrast between the 10 Shaparov plaintiffs and Milo Herbst is more stark than that. And I will just go through the list. Milo Herbst is the only one that does not have receipts for purchasing real water. Milo Herbst is the only one that did not drink home delivery water. And as Your Honor will know, that's what the FDA was focusing on. That's what started the whole thing. And that's what the experts are fighting over, but not as to the 10 Shaparov plaintiffs. Milo Herbst is the only one that did not drink the super bad batch. That's huge. And you see that in all the plaintiffs' complaints, the super bad batch. Milo Herbst is the only one that got sick prior to the 2020 outbreak. And my analogy is we all know COVID, and there's people that got sick and died during the pandemic. And if a nursing home was being sued and they said, hey, my grandma passed away in 2016 from COVID, we would scratch our heads and the evidence would be different. That's the analogy here. Milo Herbst had cirrhosis, esophageal variceal bleeding back in 2016. He doesn't fit the bill. He sticks out like a sore thumb. The 10 Shaparov plaintiffs did not. They recovered on the good hospital water. They weren't put on potential transplant watches like Milo Herbst. They obviously didn't die. They didn't have pre-existing colon cancer. They didn't have pre-existing chemotherapy that has a toxic effect. They didn't develop cirrhosis. They didn't have to go and have their ascites, which is the bloating of the stomach from excess fluid due to a failed liver. They didn't have to undergo paracentesis. They didn't have to undergo TIPS procedures. The 10 Shaparov plaintiffs didn't ask their doctor to put in a valve or a drain so he could do it himself, without having to go to the doctor whenever it bloated up. The 10 Shaparov plaintiffs didn't own bars, didn't tell their doctors they drank alcohol since they were 12, didn't have numerous medical records suggesting 50 to 60 year history of drinking. They obviously survived. This is the only one. The causes of action are different. This is a wrongful death cause of action. The other folks, you're talking, the regular strict liability. So there's no estate in the 10 Sharapovs. There's no heirs. That's unique to Mr. Herbst, who again hasn't been dead in a year, for more than a year yet. I believe his anniversary is coming up. The other ones filed suit in 2021. They don't have statute of limitations issues. Depending on how Your Honor rules on the competing statute of limitation motions, we could be looking at a statute of limitations jury instruction, factual evidence being presented on that. That's completely foreign to the 10 Shaparov plaintiffs. That we're completely different. And the 10 Shaparov plaintiffs don't have alcohol addiction or alcohol use disorder as a factual issue, with competing experts on that. And with the bolstering and everything else, we don't think we can get a fair trial if those are combined. And so based on that, we ask that the court peel off the Milo Herbst plaintiffs, try us separately, give us a date in May. You can try the Shaparov stuff on time in January, and at a minimum, so that continues it. And if you don't, you should continue. If you won't sever it, which we think you should, you'd have to move the whole thing in order for us to be prepared and engage in all this discovery based on what has happened recently and the change in plaintiff's theory of the case, based on our understanding and the new experts and witnesses.
Thank you very
Thank you, Your Honor.
Yeah, I would like to be heard if I could briefly, Your Honor. I won't take much of your time. Lord knows time's in short enough supply in this case. When Your Honor ruled and decided to consolidate this case just a few months ago, a case that's now barely 6 months old, it's clear from the record, Your Honor did not know the enormous number of documents that were yet to be produced. It's clear in the record. That wasn't available, and that wasn't, and the court's assumption that all had been substantially made available is just flat wrong.
I think to be fair to myself, I think, because you all quoted me, the way I thought I said it, there's been substantial production, if not complete. So I understood that it wasn't a complete production, but I meant substantial in terms of, I forget how many pages it was, thousands of pages at that time. So I'm not sure I agree with your characterization of what I said, but go ahead.
Well, I don't mean to do more than just point out it was a mistake, I think, by all concerned, including the plaintiff's counsel. I don't think anybody realized there have been something like 10 supplemental productions of documents since, thousands of pages, scores of more witnesses that now you've been informed were still being deposed. I don't think Your Honor knew that or could foresee that we would be deposing plaintiff's key medical causation witness 4 business days before motions in limine are due. The court couldn't have known that. And in terms of the numbers of attorneys, there's 2 defense counsel for ETT1, Terrible Herbst. And from practice and a long distinguished career before, nobody at Gordon Reese was sitting around waiting for me to say, okay, drop your other cases and jump on this one. And forget the fact you're not licensed in Nevada. Come on in with 1,000 attorneys and do what? That the resources issue would be relevant if that's all it was. There's not time. There's for people to drop everything else they're doing and 50 other states where we have an office and come attend to a case. There shouldn't have ever been shoehorned into a 6-month time period to do all discovery and be ready with pretrial motions and prepare for trial. It's absurd. There's not enough time. There was never enough time. The claims are different. The parties are different. The defendants are different than what was in this 4-year-old case that we've been shoved into. There's no getting around that. We're not going to get a fair trial this way based on bolstering alone. Even if we had the resources, what would that have to do to correct what's going to happen in this case when we're sat next to 10 other plaintiffs that have nothing in common with an alcoholic that died of liver cirrhosis, and there's 100 medical records that say that's what happened, and we're going to be tainted with all the 5 trials of evidence of real water harm, when this is a textbook case of that's not what happened here. But we won't even have a proper chance to show that if we're shoved in a courtroom with these 10 other plaintiffs. And that's in addition to the fact we simply don't have enough time to do a proper job. It's clear. I don't, so the fact we have other firms, we have 2, I have a cross claim against my co-defendant here. We have mutual defenses on and experts on numerous issues, but it's not straight down the line. And neither of us were in this case. Neither of our parties were in the case for 4 years. The plaintiff's ready to go, and they would like to get this in there, and I understand that. They're good attorneys. Why wouldn't they? Why wouldn't they argue for that? 3 weeks after Nevada Beverage answered, we're getting a ruling on a consolidation, and we're thinking we got 2 weeks to produce an expert. So naturally, we were diligent enough to do that. We did everything we possibly could, and we've done everything we possibly could. We've been completely diligent. And the weighting here of the prejudice is not, it's not for plaintiff to be prejudiced. If we're given a few more months to prepare for a trial, that there is no prejudice to plaintiff to grant this.
Thank you very much.
I would ask the court to consider our motion and grant it. Thank you.
Thank you.
Yeah, Judge, I'll start with the resources, even though that wasn't set forth in the motion. On resources, Terrible Herbst is not a brand new party to this case. They were in the Hunwartson case. They had, at one point, 22 attorneys in the courtroom standing up in front of Judge Kistner in the Hunwartson case. That goes back to January, February of last year. So it's not like they're just brought into this case. So true, there's a lot of work. I will admit that there's a lot of work that needs to be done in the next month or two. But if I can do it with 4 primary lawyers, just 4 on the plaintiff side, surely they can do it with 40, Your Honor. And that's our response to the resource argument. Now let's turn to the arguments that were actually made in the motion to start. Their primary argument in the motion for continuance and deconsolidation, which I think is more properly called severance, but their primary argument in the motion was that there were, quote, new cancer records, unquote. And they went on and on about this production of, they said, they call it 300 records. It was actually less than that, but that was made on August 1st. That is not where the cancer issue was first disclosed. As we point out, there is a March 26, 2025 production, and the cancer records and the chemo were prominently disclosed at that time. In the motion, they argued the cancer issue 5 times. They didn't even argue it today.
Yeah, so tell me, I mean, maybe they looked at your opposition, I don't know, but tell me, I think my primary issue that I want to hear about based primarily on arguments that they emphasized this morning. You know, I don't know that the resources argument is super persuasive, but in terms of the, whether you call it severance or deconsolidation of Mr. Herbst's or the estate's case.
They're arguing 2 points, Your Honor. First of all, they're arguing alcohol is something new and different in the Hearst case. Alcohol was a big issue in a lot of the previous cases, including Taquante Henry, also a case against Terrible Herbst, where they were trying to say that the alcohol was the cause, not the real water. It was a big issue in the Pam Brown case where she drank a glass or two of wine a day, the same scenario that we have for Mr. Hearst. And it was a big issue in a lot of the cases. In addition, it's an issue in this case for the Shaparov plaintiffs because they claim that Lorraine, and I'm going to call her Lorraine K because she has a very long Hawaiian name that's hard to pronunciate, but she's one of the Shaparov plaintiffs. So their argument is that Lorraine K is a binge drinker. They say this in their expert reports that she's a binge drinker, and yet despite that, they have conceded liability and causation on that case, and that's in Dr. Cohen, that's their expert. He says that both are substantial factors. The binge drinking and the real water were substantial factors in her getting liver injury. So the big debate in that case is whether or not it's permanent injury or whether or not the injury has resolved itself. That's the only debate in the other alcohol case. All the cases, all the Shaparov cases, they concede liability on. And that is critical, Your Honor, because I think that brings us to your second question, which was, I believe, focused on the Cavanaugh analogy that they gave you. In Cavanaugh, if you remember, Cavanaugh had autoimmune hepatitis, and the issue was whether or not the mechanism of action for hydrazine to trigger autoimmune hepatitis was different than the mechanism of action for hydrazine to cause fibrosis. That's why Cavanaugh was severed out, because Your Honor decided that that was a different mechanism of action. Okay. In this case, we have the exact same mechanism of action because all of these plaintiffs have fibrosis. If the court remembers, there are 4 different stages of fibrosis: 0, 1, 2, 0, 1, 2, 3, not counting 0 as a number, but 1, 2, 3, 4. What we have in this case is Shaparov and Bruce Perrin, 2 of the plaintiffs that they're stipulating to liability on. Those 2 people had fibrosis as exemplified by biopsy slides. They went up to Stanford. They're part of the Loma Linda article that's sometimes referred to as the Burke article, where the Loma Linda scientist says that this was caused by real water. If you take a look at those slides, you will see not quite the cirrhotic nodule we had in the Morales baby case, but close. But in any event, these are fibrosis cases. Both of those are fibrosis cases exemplified by biopsies. All of the other 8 are fibrosis cases to varying degrees. Mr. Hearst is also a fibrosis case. He is cirrhosis. That's level 4 fibrosis. They call it cirrhosis. So it's the same mechanism of injury in the cases. And that's why they want this deconsolidated, Your Honor, because their expert, Dr. Cohen, has already conceded that you can have 2 substantial factors that cause fibrosis in the Lauren K case. He has conceded that her binge drinking and her exposure to real water are causes in that case. They don't want that case tried with the Hearst case, where they're going to try to argue, oh, I'm amazed Mr. Cavanaugh called him an alcoholic on the record. I really am amazed. But in any event, Your Honor, they don't want that evidence to come in this case, that they've conceded the substantial factor theory in the other case. And they also don't want the evidence to come in this case, in the Hearst case, about the liver tissue slides on Mr. Parent and also on Mr. Shaparov, because then the jury will see that this is just the natural progression of real water. And that's the real reason for the consolidation, Your Honor. But with regards to the central point, the Cavanaugh case, going back to it, this is the exact same mechanism of action. Mr. Hearst is just at the end stage of it. hopefully that answers your Honor's question on that point. The other points they raised on the cancer issue, and counsel stood up today and says chemotherapy has a toxic effect, unquote. We don't think that's accurate, Your Honor, and we base that on the fact, and even if it is, it's the chemotherapy was disclosed. They have an expert on that. Dr. Atchison has already filed an expert report where he renders kind of a fuzzy expert opinion on the chemotherapy. But what the truth is going to be on the chemotherapy, and I say this because Dr. Redmond, the treating hepatologist, was deposed a week ago today. He said that FOLFOX is the name of the chemotherapy used for the cancer treatment. He says that FOLFOX cannot cause cirrhosis. I took Dr. Stealth Fluke's deposition on Monday. He said that FOLFOX doesn't cause cirrhosis. They're taking Dr. Kahn's deposition, the plaintiff's hepatologist, on Wednesday. He's already said in his expert report that FOLFOX doesn't cause cirrhosis. And I'm expecting when I depose I have 3 more expert depositions Thursday and Friday. I'm expecting to get more support for that. But if it is a theory that they want to present, they've already filed Dr. Atchison's report on it. He's rendered kind of a loose opinion on it. Your Honor, now the other point I want to make, they argued today that, oh, we're bad people. We filed these motions for summary judgment 3 weeks early. I mean, I think we should be commended for that. We tried to get it out of the way, and they forget to tell you that they asked for an extension of time and we immediately agreed to it. We gave them an extension of time already on that, Your Honor. So that's no reason for a trial continuance. You know, I think I'll rest on the fact that their final argument is, again, back to the Cavanaugh analogy, that this Hearst case stands out like a sore thumb, and it's vastly different. It's just fibrosis to the advanced stage of cirrhosis. That's just level 4 fibrosis. And there's nothing different about that. It's the exact same mechanism of action. It's the exact same studies on hydrazine toxicity. It's the exact same analysis as to why hydrazine does cause fibrosis. And so to suggest that it's something different like the Cavanaugh case, where we had to bring in the on the prejudice point, Your Honor, I forgot about that. I mean, these are not easy cases I know I've done, I don't even know how many I've done, 5 of these now? 5 of these now, and this will be the 6th, but these cases take probably about 2 weeks, and costs, just the recoverable costs are in the $500,000 range, and this costs more than that. There's been a lot of preparation today. We've already done 6 expert depositions. We're going to have all the experts done with the exception of the 2 psychology experts by next Wednesday. And the reason the psychology experts are on a different track is not my problem. It's their experts' problem. Their expert, I don't want to call it, I don't want to.
So
What he did, the special master said was wrong. And as a result of that, we're having another hearing in front of the special master to discuss this. But his report's been put on a different track because of discovery that they did, I don't want to call it a discovery abuse. Maybe it was a miscommunication between counsel, because the agreement was that they were supposed to videotape his examination of the plaintiffs, and then turns out they go, ha ha ha, we forgot to videotape it. Too bad. And that is being discussed by the special master now. And that's the reason that his deposition and Sand's deposition may be done outside of the time period, outside the November 19th deadline. But both of those are psychiatric injury, Your Honor. So I don't think we've already offered we stipulated to a damages number for them. I believe in the Wren case, I don't know if you recall, we stipulated, I can't remember if it was 30,000, 60,000, it was something like that, because it was not a big ticket damages item in the case. So both parties stipulate to it. We've offered them the same stipulation in this case, despite the fact that their expert's probably going to get stricken. But in any event, the fact that these 2 depositions are going to be taken outside the window doesn't mean that the trial should be continued. But finishing with the prejudice point, Your Honor, it's not just me and my firm that would have to do it again. It's you that would have to do it again. So you're doing the exact same case again under their proposal in May that we're doing in January. I just don't think that makes any sense when you have the exact same mechanism of action. Thank you, Your Honor.
Thank you. Any rebuttal?
Thank you, Your Honor. I'm gonna come up to the top. I understand I'm on a pitch clock. I will be short. Everything Mr. Kemp said supports severance. He's conflated a number of issues. And I need to say this not just to clarify the record but also because it supports severance or deconsolidation or whatever word we want to use. Dr. Cohen is not Nevada Beverage's expert. It's not Terrible Herbst's expert. Dr. Cohen is Real Water's expert, and he's only opining as to the 10 Shaparov plaintiffs. He's not opining as to anything related to Milo Herbst's injury or death. That again shows the prejudice and the confusion. When even plaintiff's counsel is confused, I can't imagine a jury not being confused when counsel that's been living this for 4.5 years is confused. And I heard a lot of we, and they. The pronoun game continues with conflating. There's been no concession. Nevada Beverage does not concede anything. We're fighting tooth and nail. Again, Mr. Kemp's referring only to Real Water, which is not a party to this motion. Real Water can try against the Shaparov folks at Shaparov trial time. That has nothing to do with Terrible Herbst or Nevada Beverage. In terms of the resources, whatever happened in Hunwartson is immaterial. Nevada Beverage was not a party to that trial. We got out relatively early. That's moot. I want to speak briefly on the cancer records, because while he had cancer, Mr. Kemp is right. They're not claiming damages or related in their 16.1 computation of damages, anything related to the colon cancer in 2008 or the colon cancer treatment in 2009. What's of concern is in their computation of damages, and we produced this, I think, in their 25th supplemental disclosure, is a random 2011 medical record. And I'm trying to figure out what that is doing there on somebody who's the fact sheet and everything else and everything they talked about at the initial consolidation hearing was, well, this is 2016, the injury. And what did we talk, date of injury, data loss, and we talked about that in the statute of limitations context. I don't know about that, and I won't know about that until next week when we depose Dr. Khan. And in terms of the alcohol, while it's true there was an alternative causation defense in some of the other cases, and I believe Daniel Thomas was physically intoxicated at the time of his medical visit, ER visit, and we did, for Henry, he was suing us, and his alcohol was part of our defense. What is new and novel in this case is this new theory that it's some synergistic or additive effect of hydrogen plus alcohol causes the problem. And we've always argued, hey, you have to rule out alcohol first, and you'll see that in our one of our summary judgment motions to be heard on the 3rd. This is new, this synergy that, this explains it. This is the smoking gun. It's only the heavy drinkers that are succumbing to Real Water toxicity prior to the outbreak. That's new and novel. So to say that, well, there was other people that drank a lot of alcohol in the prior trials, it's disingenuous because the context is entirely different. The other thing that separated Cavanaugh was not just the mechanism of her injury and the result of the autoimmune hepatitis, but also the timing. She was a 2018 patient. So that was different. Again, she wasn't suing my client, so I don't have the intimate knowledge of the details like the counsels that were prosecuting her family's claims or defending against them. But she stuck out like a sore thumb as well. Your Honor recognized that, and we ask Your Honor to recognize that here. In terms of the timing of the MSJ, 2 of those were based not on discovery, but based on court records from the other trials. They didn't do us a favor by filing them in the middle of expert discovery. If they had a true belief in those motions, and of course we don't, we opposed it and filed our counter, they could have filed that early in the case in an interest of judicial economy and say, well, if there's a slam dunk, if there's a easy button to hit, they could have filed that early like we did with our statute of limitations. So to file it, to sit on a motion like that for months, which is almost verbatim what they filed in some of the previous two cases, they could have filed that back in March, April, May, or June before we're in the midst of discovery. And so that's where the prejudice comes in. And in terms of the delay of Dr. Sand's rebuttal report, again, this pronoun game comes in, and we're extremely concerned because, again, I'm assuming plaintiff's counsel's confused. And again, if plaintiff's counsel's confused, I can't imagine the confusion on a jury because we don't have a psychology expert. The Shaparov plaintiffs that are suing Real Water and Real Water only are making emotional, psychological type damages for which Dr. Sands is their initial expert. And those claims are only directed at Real Water, and Real Water has their own psychologist to rebut and refute and present all that stuff. I'm not in that. Nevada Beverage isn't in that. Terrible Herbst isn't in that. I have nothing to do with the delay in Dr. Sands being available to be deposed and testify as to his rebuttal report on our addiction expert, Dr. Moss. So again, that was a misstatement, and everything Mr. Kemp said in that regard supports severance based on the confusion. And I can't emphasize this enough. Nevada Beverage has never been at trial. I have never addressed a jury in a Real Water case. I've never argued jury instructions, made opening statements, all the fun trial stuff in a Real Water case. We've gotten out for various reasons on a number of those cases. And remember the context here, Your Honor. We're here, trial setting conference. I'm asking the court to sever a guy that sticks out like a sore thumb and all the reasons you've heard. And we're asking you to continue the trial. You're not here on a motion in limine. We're not arguing the merits. This expert is good. This expert is bad. Kick this out. Exclude this. Exclude that. We're not here yet. We'll do that in early January or whenever. But yet, Mr. Kemp is focusing on, oh, well, if they're going to argue the cancer, this or that, and if they're going to argue the alcohol, this, that, and the other, and the effects of the chemotherapy, again, if that's an issue of fact, the jury is going to hear that. That's a complete waste of time as to the Shaparov folks. The jury's going to be confused. You can't unring a bell. I can't imagine any amount of limiting instructions that's going to do that. And the very fact that Real Water's expert, Dr. Cohen, says, yeah, our Real Water caused those 10 plaintiffs injuries, you would expect somebody that was injured by a product that we know they subscribed to during the known reported outbreak period, you would expect that. None of that has anything to do with Milo Herbst. That's not when he bought the Real Water, allegedly. He never subscribed to it. And his injuries date back maybe to 2011, if you believe their 16.1, 2016, if you believe plaintiff's fact sheet, and I won't find out till next week what Dr. Khan says. It's not the same sport. This is baseball and oranges, and I've already mixed more metaphors than I usually do because I can't emphasize it enough for Your Honor. Milo's different. I'm going to say a horse of a different color because I just watched The Wizard of Oz for another reason. But I'm going to rest, and I'm going to beg Your Honor, separate out Milo Herbst. He doesn't belong there. Continue us so we can get a fair trial and everybody can be properly prepared, informed in the premises, and the jury won't be confused.
Thank you.
Thank you.
Any further rebuttal?
Your Honor, just briefly, and it will be brief. there really is no prejudice to plaintiff's counsel or to the other 10 plaintiffs in the Shaparov matter to deconsolidate and continue this trial. And no prejudice to Mr. Kemp and his firm. They have 2 other wrongful death cases now that have been recently filed in the last few months. I know because one of them is the Stephen Soteros case, and my client's been brought into that. Those are death cases. The Shaparov case, the Martinez case, the Rick case that we're being combined with, none of those are death claims. And they're different defendants. And there is no prejudice to plaintiff to now knowing what the court now knows would be, we would ask that you deconsolidate and recognize that this is not prejudicial to plaintiff, and it would ensure that defendants can get a fair trial. Thank you, Ron.
Thank you. Court is going to deny the motion to trying to read deny the motion to continue the trial and to deconsolidate for the reasons articulated in the opposition, which I've rapidly run out of time. But it was interesting as the arguments from the briefs were a bit different than arguments raised here. Now, some are certainly the same, but the emphasis in the motion was, hey, we didn't know about the cancer and the chemo. And yeah, that's still an argument, but certainly not the emphasis of argument this morning. But the court consolidated. Originally, this case had been set for trial in the fall and now is set for trial in January. The resources argument on the defense side, which was emphasized, is certainly not good cause given the circumstances here. The issues don't have to be identical for consolidation. There are certainly a lot of overlap, both factually, medically, etc. So denied for those reasons I've stated, but also for reasons articulating the opposition. There would be harm or prejudice to sever. That's all now.
Your Honor, Dan Polsenberg for ETT. I'd like to move for a stay under Appellate Rule 8. Honestly, this is, I had 40 years. I don't think I've ever seen a wrongful death action go to trial in less than a year. And I think the only reason it's happening here is because the Herbst case is being linked to old cases. So I have to, obviously, we all know when I show up what I'm up to. I'm considering a writ petition, and to ask the Supreme Court for a stay, I have to ask you first.
Any response?
Judge, first of all, I think Mr. Polsenberg's memory is slipping because he said in 40 years he's never seen a wrongful death case tried in less than a year. He was actually in the Cavanaugh case with me that we tried in 2018, which I think was about 9 months after the death. So I think he should correct the record of that. But second of all, Your Honor,
Check that.
okay. Second of all, Your Honor, if he wants to file a motion for stay, I think he probably ought, and I'll stipulate to motion. day, we can do this whenever.
I mean, you're gonna have to come back in front of me soon anyway, cause I have
Right,
to. So.
Tomorrow, Judge?
Not that soon. So you all told me I've got, cause I can't do, anything else, cause I've got a trial and I've got a lot of people still behind you. I could bring you back next Wednesday.
That would be fine with me, Aaron. We can work out the schedule.
Close at Discovery, I think, Wednesday.
Yeah, Cons Depot, but
Your Honor, could we have it a day after that or something?
So-
No, well, I'm sorry.
So,
I
so-
was saying tomorrow.
I'm sorry, there's 8 depositions that day and it's closed at Discovery.
That's right, I don't do that.
So, okay, here's your two options. So. I have civil. I have civil Monday and Wednesdays. That's my civil calendar. For better or worse, I don't just do civil. I have a criminal, and those are Tuesdays and Thursdays.
Should we have a special setting at 4 o'clock on Monday? Something like that? I don't think the argument will take long.
Well, Monday, I mean, we can, no, I mean, I can do either next Monday or next Wednesday. Both of those are much lighter than my calendar this morning. I hopefully will not be in trial. But so pick a date or I'll give you a Monday or Wednesday.
Wednesday, fine with me, Aaron.
Okay.
I'm a second judge by, they'll tell you the problems, new firm security procedures. I honestly think we could have argued that.
Well, most of your colleagues are saying they don't want Wednesday on your side, so let's bring it back on Monday. Monday works for Plain? Okay, Monday at 9 a.m.
It's okay, Mr.
The 24th?
17th. Today's the 12th.
Right.
Got it. Yeah, that's great. What time, Judge?
Monday, 9 a.m.
Thank you very much, Your Honor.
November 17th at 9 a.m.